Ladies and gentlemen, welcome to the QUT Faculty of Law for today's conference on intellectual property and education in the age of COVID. As is always the case, we'd like to acknowledge the traditional owners, and in keeping with the spirit of reconciliation, we acknowledge the traditional owners of the lands where QUT now stands and recognise that these have always been places of teaching and learning, and we wish to pay respect to their elders, past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islander people continue to play within the QUT community. And in the context of debates around intellectual property and education, there has been very significant discussion about the importance of Indigenous intellectual property. Today's event is going to look at some of the relationships and connections and intersections between intellectual property and education. It will cover many different species of intellectual property, spanning copyright law, trademark law, patent law, trade secrets, and questions of licensing. In many ways, the conference today is also going to span an array of different disciplines within education, everything from the creative industries to medicine and biotechnology and even clean technology. In addition, this event is also going to focus upon open licensing within the educational institutions. So the use of open licensing to promote open access, open innovation and open data is also a very kind of important dimension in terms of the debate and discussion over intellectual property and education. This event is also going to focus upon the role of universities and educational institutions and research organisations in responding to the coronavirus COVID-19 public health crisis. So universities and research institutions have a very particular special role to play as keystones in the knowledge infrastructure. They are generating a whole wide range of technologies that could be of use in tackling the coronavirus crisis, including vaccines, treatments and diagnostics, as well as a range of other public policy solutions. So this event, amongst other things, is going to think about ways and means in which we can encourage public transfer of some of those research and public policy solutions. Finally, this event is also going to be an Australian launch for this research handbook on intellectual property and technology transfer, edited by Professor Jacob Rooksbury from Gonzaga Law School. This collection provides a comparative analysis of how an array of different countries manage intellectual property and technology transfer from educational institutions, and also kind of includes a contribution by myself looking at intellectual property and higher education and 3D printing. So welcome everyone. I hope you enjoy today's range of presentations looking at different aspects of intellectual property and education. Thank you. Our next speaker is Brendan Nugent. He's going to deliver a paper as part of a collective. Brendan is a Masters of Philosophy candidate at the Graduate School of Business. He is a patent and a trademarks attorney and has done a lot of work in the government and university sectors, particularly in relation to pharmaceuticals and biotech. And at the moment, he's very interested in the economics of the patent system. And his paper today is going to be looking at law, linguistics, and economic approaches to measuring the scope of patents. Brendan.
Thank you very much, Matthew. It's great to be here. Thank you for inviting me, and good morning to everybody. As Matthew, I think, indicated in his opening remarks this morning, there's a hope that the patent system won't interfere with the world's approach to this pandemic. I think from my experience as a patent attorney, I'm quite certain that it will, that there will be patents filed for the innovations developed now. I know this when Hendra virus first emerged. I was involved in patenting things around that in about 2004. It took until 2012, in that case, for a vaccine to be developed. So I don't think it had quite the same intensive research effort as this one. And we'll see things move much more quickly. And I think initially licensing and things like that will deal with any issues. But around SARS and avian flu, for example, we certainly saw a spike in patenting activity. They went to grant, and I think we will see the same thing again. And I think in time to come, people will need to pick through that and undertake studies of the type Anita's just described, for example. Have a look at who the players were, do competitor studies, and one of the tools they'll use is patent counts. And so that brings me to what this talk is about. The use of patent counts in economics has been known for some time. There have been a number of measures applied, and I'll describe briefly some of the reasons why perhaps those measures don't find a clear basis in the patent law and patent practice, and talk about some of the things we've looked at and some of the approaches we've taken to perhaps developing something different. The importance of patent scope. So why is it important? Well, a patent isn't really a binary situation. It's not a case of getting a grant, making an application, getting a grant or not. In fact, the thing is subject to a certain amount of, to a process. First of all, a broad patent application is drafted by the applicant. It includes broad independent claims and then a bunch of fallback positions that, because the person drafting doesn't quite know what will happen, then the application is examined by the patent office. They look to see whether the invention is new. They probably bring up things that the applicant didn't know about. So maybe those fallback positions come into play. So the claims are often amended during the process in response to objections of the examiner. And that's a process that takes some time, involves an expenditure of a significant amount of money and effort. So it's quite important to remember that. So why is it important? Well, the extent of the exclusivity granted by a patent is determined by the words used in the claims as allowed by the examiner. And the Economic Literature Meeks 2010 indicates this is what determines the value of a patent. Okay, so when in the economic literature we've considered claim scope, the measures that people have used typically are, one is the number of claims, another is the number of technological classes into which an application is classified. So the first one, as I said, we start with a broad claim, draft a bunch of fallback positions. So the number of fallback positions that we draft, the rationale for this measure is that the more fallback positions you can draft, the more complex the invention must have been, therefore the more nuances, therefore the broader the invention must be. And that makes a certain degree of sense, but there's a practical limitation to that I'll come to in a moment. The second measure is the number of technological classes. So let me explain that one. When a patent application is filed with the Patent Office, they classify it into a patent classification. It goes back to the old days, back when I started in the business, before computer searching, before keyword searching. You needed to reduce the number of things that you had to search to 100 or 200 to make it feasible to search manually. So we classified to a very fine level, and the International Patent Classification has 8 volumes of classifications. There are 40 or 50,000 classifications in it. It's a massively complex body of work and quite elegant. Now, why are these explainable in other ways? Okay, so why do these things perhaps not reflect practice? Well, the number of claims can be restricted by patent officers who don't like to examine multiple claims, so they actually charge excess claim fees for claims in excess of 20 in the US, in excess of 15 in Europe, and that drives your strategy. So while in an ideal world you might have drafted 60 or 70 claims, you almost always restrict to those 15 or 20. So it's taken away that measure. I think it was probably a valid measure to an extent at a certain time, but it's been taken away from us. And the number of IPC classes, well, there are several different classifications, the IPC, the US classification, the Community Cooperative Patent Classification, CPC. I mean, the question is which classification works, which level of classification, and I think the reality is the idiosyncrasies of the classification probably override any other effects that you would see. And I've done some detailed work on that people are welcome to discuss with me if they wish, but I think I'll leave it at that for the moment. In recent years, a new measure emerged. Around 2008, there's a paper, Malofsky and Barney, who talk about the word count in probably the main claim, or sometimes the broadest claim. It depends on who you read. Kuhn and Thompson validated that against the observations of practicing patent attorneys and found that that was quite a good measure. And I think it is a good measure. It might seem a little strange that a simple word count might reflect patent scope, but when you think about it, each time you add a word, or at least a significant phrase, to a patent claim, you're adding a further limitation. So the more words, the narrower the claim is. At least that holds true in mechanical and electrical patents, things to do with devices. It actually doesn't hold true with chemical and biotechnological patents, as Kuhn and Thompson acknowledge in their paper. And we're going to replicate some of their work and test it in those different fields, try to come up with some rules for those different fields, and also just test it again and try to refine the model a little as well. So why is it not the greatest measure of claim scope in the world? Because in the legal literature it's replete with quotes like this. Inventions are tangible, yet patents comprise words, and words are imprecise. I think all the lawyers in the audience will understand that. Words are imprecise. We make our living out of nuances in words. And so an approach which just uses the word count probably has an underlying assumption that we all use words in much the same way, therefore the actual words don't make much difference. And I think that that's something that we want to dig into a little bit as well. So I'm going to discuss that in relation to this invention. Okay, we're going to look at a patent claim very soon around this invention. But I've put up this slide, which is an embodiment of the invention, and I just want to talk about that to give some context to what we're going to look at in this research. And I'll be introducing the elements of the claim sort of that coalesce from a broad consideration of patent law around the world. We get certain elements of the patent claim that we need to look at if we're going to determine patent scope in a way that doesn't involve a distinct analysis on each occasion. So if we can automate or semi-automate the process to get a rough figure. So this invention is I thought, topical because this thing is a low-cost disposable molecular diagnostic device. It's actually a strip of paper. That's an exploded view. So there are three dispositions, and I regret I don't have a pointer here, but disposition A, B and C across the page. In disposition A, in that exploded view, what we actually have is 5 layers of paper that are all doubly glued together, in fact, and you can see that there are 3 wells formed in the paper. And the well to the left, the far left, is where we will put a sample which might contain virus. It might be a blood sample from someone, it might contain a DNA or RNA virus. It will go down through a filter. It will then get to the second layer of paper where it will meet some reagents that will destroy the cells if there's cells there, and then a third layer of paper where there's a reagent printed into the paper which will capture any nucleic acids there, any DNA or RNA there. So the virus DNA or RNA is caught in that third layer, the far left-hand well. Now the clever thing about this invention is that the middle layer is not stuck in there at all, it's just sandwiched in. And so in disposition B, we see that we have now slid that third layer to the right, and we have moved the well that's formed in it to the middle. And it's now aligning with the wells in the middle. And so then what we do is in the second stage, we add buffer solution to that. It washes down through the well, picks up the amplification reagents along the way, goes down and performs an amplification reaction. If there's been any DNA or RNA present in the sample, it will be present in the capture, it will have been caught, and it will be amplified in that reagent. And then the bottom layer, we've got a heat zone and so forth. That's quite optional. And you'll see when we get to the claim, it defines this invention in terms of 3 layers, not 5. Okay, so that's an important point to remember. Now, in the third stage C, we slide that middle layer further to the right. We put some buffer down the far right-hand well, not the middle one as that arrow seems to infer. It picks up some detection reagents. It goes down to where the amplified DNA or RNA is. It could be colloidal gold or something like that. It will react and it will get a visual signal. You'll peel that back and you will see a signal on the test strip. So quite a clever little device that could well be used to test for coronaviruses and all sorts of things in the field quite quickly, provided you've got the right things to amplify that DNA. You just need to know the sequence and you can amplify that. So I think that's probably the type of thing which is out there being used for very rapid tests at the moment. So how does it fit into a claim, and what are the elements of a claim that affect claim scope? So the first element that affects claim scope when we distill legal principles and try to pull them all together is this: the conjunction used between the introductory portion of the claim and the body of the claim. What do I mean by that? Okay, that claim 1 of that patent application starts a molecular diagnostic device. So that's what it is, it's a device. Then there's some non-limiting terminology, and our broad word count, by the way, won't pick up that the words following 4 are non-limiting in most interpretations. For detecting a characteristic of a polynucleotide analyte in a sample, then it says the device comprising. The conjunction is the word comprising. You can use various conjunctions consisting essentially of, including. The meaning of it, it's the first significant element where we change the meaning of the claim. Comprising has an inclusive meaning. It means the object has the integers recited thereafter and may have other integers as well. Usually that's the one that used from an economic point of view. It's probably not all that significant because it doesn't vary a great deal. You know, you really only use something else if you get forced to. Our second element in the claim is somewhat along the lines of word count. So here I'm formalising this word count idea, the number of integers or elements recited in a claim and their interaction. This is what we do as attorneys or lawyers all the time. We look at what the integers or elements are. And in this claim, the first paragraph after the conjunction read, at least first, second and third substantially planar members for collection and amplification of a sample. Remember the strips of paper? Well, they're substantially planar members. We'll get to that in a moment. But the key thing here is there are at least first, second and third planar members, not 5 as we saw in the drawing, but 3 that are actually significant. And they're introduced here. Those are clearly elements or integers of that claim. And when they're referred to, each of them is referred to the first time, it's usually by the indefinite article, or or an, or here, at least. So there's only very slight variation in the terminology used to introduce those words the first time. Then later in the claim, we return to discussing those integers. And here the claim says, at least one of said members being adapted for lateral movement. Remember it slid, the middle one slid? Well, that's the one we're talking about here. But when we refer to it the second time, we talk about at least one of said members. Usually we use the definite article, the or said. So we can pick up some patterns in the claims, and I think what we want to look at is trying to identify the integers sort of automatically, if you like. We do this manually, but identify them automatically and try to refine the word count. And in order to do that, we're going to need to look at linguistic models, and Nancy's going to pick up on that in a moment and discuss them in a different context, and we'll be looking at those with a view to trying to interpret claim language to just refine that word count measure a little. The third element of a claim, which I've already alluded to, which I think is overlooked in the previous measures, though it's picked up in the prior, the conventional measures, I must say, they just suffer from those practical limitations. The breadth of language used, and why is that important? Well, the planar members, remember those, the strips of paper? Well, the planar members are not defined as strips of paper at all for very good reason, because there's a lot of combinations and permutations of things that can happen here. So they're defined functionally. And they're said to include fluid impermeable barriers which define boundaries of hydrophobic regions therein which support fluid flow there through. So those are the wells. Why is it defined that way? Why didn't we just say there's some holes in a piece of paper that line up and we put some buffer down? Because obviously there's different ways of doing this, and a couple of different ways of doing it here. Some of those strips of paper have adhesive on them, printed onto them, and the adhesive itself is a barrier, so fluid will not pass through the adhesive but will go down the well. So they simply align them by gluing them together. And then the paper is probably in physical contact and the fluid will go through. But in other embodiments, they use adhesive strips to join the paper. The adhesive strip forms the barrier, but then the pieces of paper are spaced apart. And so in order to make the fluid go through properly, they tend to fill that up with cellulosic particles. So this is why there's broad functional language there rather than specific language defining something. And that's the sort of thing that I hope to try to bring into the equation in analysing scope. But that is very difficult to do without thinking, without analysis, and that's where the models, the linguistic models, we hope might turn something up there. So for the sake of completeness, the remaining elements really are, when we're talking about the scope of a patent, as lawyers we often talk about the scope of a claim, but patent scope, look, sometimes there can be an interaction with other claims that will broaden the scope overall of the patent. In this case, this particular patent there wasn't really, but Claim 27 was an assay method which did refer to the device of Claim 1, but could have been more general and tried to define that concept of using that sliding layer without reference to the device. So we need to look at the remainder of the claims as well and see how they interact with the main claim if we want to talk about patent scope as opposed to claim scope. And the last thing we need to look at that might come as a surprise is that if there's anything in the description which modifies the meaning of a term used in the claims. Now, there's a bunch of warnings in case law that say don't use anything in the description to modify the meaning of a term in a claim, but there is an exception, and that's when something is clearly used as a definition. And in this case, in Claim 14, I think it said that the planar members are made of paper. So we think, okay, what's paper? Paper's paper, it comes from trees, but when we refer to the definition in the specification, we see that in fact it's intended to include any absorptive porous sheet or that is likely to transmit fluid by wicking, and it includes nitrocellulose sheets. So it has a somewhat different meaning. So we do need to consider that in the process if we're going to reach an interpretation of a claim somehow automatically. I think in most cases it won't have an effect. It's actually quite rare in mechanical and electrical cases to do that, but very common in chemistry and biotechnology. So those are the elements that we want to look at. And essentially what I'm describing here is our project which is going to happen. So first of all, we're going to look at traditional measures of patent scope, and as I've explained, they're imperfect for a number of reasons. We're going to validate the word count. We think I believe it's a rough proxy of the number of integers in the claim. I think that's where it has its merit, and we're going to look at to see if we can refine that a little. But no measures so far really look at the breadth of language used in the claim, so we want to look at how we can do that and do that automatically. So in future work, we're proposing to sort of look to introduce our work into linguistic models as well, and with all of that, try to come up with some sort of measure of patent scope that can be used in econometric studies of the type that are conventional as Anita described. Thank you very much.